you've written arguing that the citizenship clause of the 14th Amendment creates a positive right, I would summarize, to whatever benefits are at least necessary to fulfill full participation as a citizen. And you go on to note in your interstate inequality and educational opportunity piece that the 14th Amendment, quote, guarantee of national citizenship was a generative source of substantial rights. I'm uneasy a bit to suggest that this plain words of the 14th Amendment are generating rights, and but besides that, and you wrote that citizens have quote, positive rights to government assistance, as I understand it, and that is rights derived from the Constitution, as I understand it, and that these rights can be guaranteed not only against state abridgment, you wrote, but also as a matter of positive right, close quote. And you concluded that such an agenda, a constitutional agenda, would, quote, include expanded access to health insurance, child care, transportation subsidies, job training, and a robust earned income tax credit, close quote. So do you believe that, yes or no?
I do believe that, Senator, but those arguments are addressed to policymakers, not to the courts.
Well, that's important, and very important distinction. I'll review that. It does seem to be consistent with your view of expansive governmental powers.
Thank you, Senator.
One thing, and I'll conclude this remark, and that is that, as you noted, both with Alito and Roberts, judicial philosophy is important. Your writings are the only thing we have to evidence that, and I don't think it's sufficient just to say that I'll follow authority somewhere in the system, because many, many times you'll be a case of first impression will be before you, and your philosophy will indeed impact how the law is shaped.
Thank you very much.
Thank you, Madam Chairman, and for your patience. I want to get back to this question of agenda that I was talking about before we had our little break. You, in a broadcast earlier this year, January 3rd, on NPR, were discussing how the Obama administration represented a new opportunity for the American Constitution Society. And you said that under the Obama administration, and I'll quote this now, that ACS had the opportunity to actually get our ideas and the progressive vision of the Constitution and of law and policy into practice. What did you mean by our ideas and your progressive vision of the Constitution and law and policy?
Senator, I think that was a reference to the ideas that underpin the American Constitution Society, and I think as the mission statement of that organization reads, it's a dedication to certain principles of our Constitution, genuine equality, liberty, access to the courts, and a broad commitment to the rule of law.
Is it fairly described as a progressive vision or progressive?
I think many people have described it that way. I think that's fair, yes.
Now,
the organization,
yeah.
I mean, not necessarily. I think the values are those of the Constitution. I don't think I wouldn't say they're progressive or conservative or whatever. I think those are the values in the Constitution.
Well, the way you described it was the opportunity to actually get our ideas and the progressive vision of the Constitution and law and policy into practice. So I assume you subscribe to these views when you talk about our ideas.
I think as I think the record shows, Senator, I have been deeply involved in the American Constitution Society. I have served on the board. I've chaired the board.
There's nothing wrong with having views that are wrong. No, okay. But I mean, so that's what you meant by the opportunity to actually get our ideas and progressive vision of the Constitution, law, and policy into practice. But I guess the follow-up question is, obviously, you I guess you would say you were speaking in a policy way, not through the judicial process. Is that the way?
I think, well, Senator, the short answer is yes. And in addition, I think that, look, I mean, I think every president has his or her own views of what vision they would like to enforce as a president. And I think, I don't think I was meaning anything more than just that basic prerogative of the president.
Policy through the appropriate ways of implementing policy.
Absolutely.
And what you're
yes.
suggesting is that it isn't appropriate for a judge to have a policy agenda which he brings to the court and to try to get that agenda adopted into law.
Absolutely, and I think it would not be appropriate for any president to appoint a nominee for a judgeship because of that nominee's agenda.
I mentioned to you before two of my colleagues, one of whom is the chairman of the committee, and I'll just quote from a April 13th article in Politico. He was talking about things, the Ledbetter case and the Citizens United case, and I'll quote him here. But I think what people are going to do is say, do you share our concern about the fact that the court always seems to side with the big corporate interests against the average American? End of Chairman Leahy's quote. Do you think, first of all, that that's an accurate characterization of what the Supreme Court does?
I think the Supreme Court tries as best as it can to apply the law fairly and equally to all interests of the society, whether they are ordinary people or corporate interests.
Do you think that if you were on the Ninth Circuit Court of Appeals that you would have a biased or a preconceived notion or an agenda to try to right a balance and rule more against big corporate interests?
Absolutely not, Senator.
How about in cases where the question of executive power versus legislative power or judicial power is concerned? Do you think that executive power has gotten too big and that the courts should try to rein it in and rebalance so that the executive power is more limited vis-a-vis the other branches?
Senator, I couldn't say that I have any sort of theory of that sort. I think courts can only decide the cases that are presented to them based on the applicable law. And sorry.
Excuse me for a moment. So your view would be that if this committee tried to promote a nominee because of our belief that that nominee would rule against big corporate interests or would rule against executive powers, that would be an inappropriate basis for us to base support for a nominee on. That's bad grammar, but forgive me.
I think that, obviously, Senator, I won't pretend to suggest what standards this committee should use in evaluating a judicial nominee. That's clearly your prerogative and not mine. I would simply say that for all judicial nominees, I think I would hope that the important test is whether the nominee would be faithful to the law that has been given, and